Now we're going to look at the different elements of an arbitration agreement. A lot of the times when we see arbitration agreements, they just look like one big huge paragraph and just a whole bunch of stuff going on in them. But we're going to break it down, see what each one of these elements are. What does this mean? What does this verbiage mean? What does this verbiage mean to us? And like, what is they trying to convey or tell us essentially? So one thing I noticed over the last 3 years since I've been doing arbitration is a lot of these agreements are templated. So they almost just about look the same. But these are 13 different elements that I see a lot of arbitration agreements have. They don't always have the 13 things, but they will have a majority of these things, at least 10 out of the 13 things within the agreement. So we're going to break down what the waiver of rights is. So essentially the waiver of rights is agreeing not to bring class action, not to have no jury trial. That's usually bolded and at the top of the agreement, but we'll look more into like each one of these elements individually. They'll also talk about discovery. Like while I said before in previous lessons, discovery is limited, but discovery happens whenever there is a subpoena issue. So the subpoena could be issued to either have somebody come in to be cross-examined and questioned, or the subpoena can be for a production of documents. So that is what discovery is going to talk about in arbitration agreements as well. Governing laws is also talked about in arbitration agreement. So these are the set of laws or rules that will control the agreement. This is very important, and they're also going to clarify which set of laws or rules is going to govern the arbitration when you get on that hearing conference call. The next thing you may or may not see, I don't see this in a lot of arbitration agreements all the time, is rejecting the arbitration clause. Some companies do give you a chance to opt out of arbitration when you first apply for the account or you first get approved for the account. They usually have a small window in which you can go ahead and exercise that right to opt out. If you don't, you miss that window and that right to opt out forever, essentially. Another thing that is optional and I don't see a lot in arbitration agreements, I see them in some, but I don't see them in all of them, is the pre-arb notice or the notice of dispute. Like I was telling you on previous lessons, some companies require that before you file a demand for arbitration that you send them a notice of dispute or a letter letting them know like, hey, I want to arbitrate you guys, but this is my issue that I'm having with you guys. And they usually ask to be allowed anywhere from 30 to 90 days to try to resolve the problem before actually filing for arbitration. The next thing that arbitration agreement is usually going to detail out is the type of hearings you can have. So this will determine whether you can have an in-person hearing or a documents-only hearing. So some companies are flexible and say, hey, you can pick whatever type of hearing you want to pick, while other companies say this matter will be resolved by documents-only arbitration. So we'll look at those, how that verbiage looks in arbitration agreements as well. It also going to go over the type of claims. Most of these companies' arbitration agreements say any and all claims, any claims. It is very broad. Well, some of them could be very limited in scope and say all claims except these, right? So we're going to look at what that looks like in arbitration agreements. They're also going to go over fees and payments. Who's required to pay what? Who's going to pay who back? If they're going to reimburse it, if they're going to cover it. They're going to tell you who's responsible for paying what and how much. The next one is venue. So they're going to tell you which arbitration company can you use. Can you go to JAMS? Can you go to AAA? Or can you choose whichever one you want to choose? So we'll see what that looks like as well. Sometimes I see this one and sometimes I don't, but they'll tell you how many arbitrators you can use. So not only is they going to go over the number of arbitrators, they might say this will be decided by one arbitrator, or it might say this will be decided by 3 arbitrators, right? They'll also tell you things about the arbitrator. What are the qualifications that this arbitrator have to have? How many arbitrators will be on the case? Who can the case be assigned? When and will the case will be assigned, and essentially things of that sort. So they're going to tell you what their bare minimum arbitrator requirements are within that agreement. They're going to also talk about the award. If they have any limits on how much you can get in arbitration, they're going to say that, like, hey, you can cap out at $75,000 in arbitration, or there is no cap. If the arbitrator awards you $5 million, $24 million, so we've seen cases as high as $24, $48 million in art. They're going to say that in their ARB agreement. If there's a limit or no limit, or they don't mention it at all, then essentially it is deemed to have no limit. They're also going to go over if there's an appeals. So like I told you guys in earlier lessons, they don't always allow you to appeal in arbitration. Sometimes you can only appeal if it's over a certain amount. So I believe like in the Mercedes-Benz car contract that we've seen before, Mercedes said if you beat us and you get awarded over $100,000, then or we get awarded over $100,000, we have the right to the appeal, or you have the right to appeal. So if it's anything less than that, there is no appeal. But if it's anything more than that, then there's an appellate process that can be had, and they can appeal the arbitrator's decision essentially. And last but not least, survivability clause. I have seen this in every arbitration agreement every single time, 100% of the time. This is by far the most important part of the arbitration agreement, if you ask me. But the survivability clause essentially tells you how long can you bring this company into arb, and when you can bring it. Like it's essentially like your statute of limitations, right? Except it don't expire, which is by far the best thing ever. So I'll see you. This is gonna wrap up this lesson. I'll see you in the next one, and we're gonna get into each one of these elements individually, and we're gonna break it down and see what they look like on these agreements. See you later. Welcome back. Now we're going to look at waiver of rights and discovery. These two things are usually right next to each other on the arbitration agreement near the top, so that's why I combine them together. So let's look at what that looked like on the agreement. So this is normally how it appears on the arbitration agreement. It's always in bold. It stands out from the rest of the arbitration agreement because it is important and because it's dealing with your rights. So it usually states, like how this one does, that arbitration is mandatory since the disputes are decided by arbitration and not in court. When you see verbiage like that, where it says any dispute between us decided by arbitration and not in court or by jury trial, that means you must go to arbitration. That means arbitration is binding and mandatory. Court is not an option for you if you see that type of verbiage in there. They also, as you can see, told you that you have to waive your rights to a jury trial. And the second one says that discovery and rights to appeal and arbitration are generally more limited than in a lawsuit, and other rights that you would have in court may not be available in arbitration. So, like they said, discovery and rights to appeal is usually limited. Like I told you guys in previous lessons, it's very selective reasons under which you can appeal. And then same thing with discovery. Discovery is very limited as far as the scope of discovery. How much stuff could you request? How much stuff could you ask for? It's limited in scope in order to keep the process efficient and expedited. A majority of the time, cases will settle, so you will not need to really engage in discovery or appeals, essentially. But if you build your case properly from the beginning before filing for arbitration, you really don't need to discover anything because you got all the documents that you needed. You got everything that you needed from the company prior to filing for arbitration. But this will wrap up this lesson, and I'll see you in the next one. Welcome back. Now we're going to look at governing laws. So we're about to look at and see how do they lay out which laws are going to govern the arbitration proceeding, what is not going to govern the arbitration proceeding, and what that means for you going forward as you move through your arbitration hearing. So most companies will make it clear which laws will govern. When they say it's governed by FAA, they're referring to the Federal Arbitration Act. I highly suggest that you read that in order to have a better understanding of it, because that is the laws that's going to govern your actual proceeding. This company made it clear which laws are not going to govern. So sometimes we'll see this in arbitration agreements. Most of the time, they only say which laws are going to govern. So they'll be like, okay, the arbitration hearing will be governed by FAA, and state laws will also apply, right? So you will be able to know, like, okay, I can use FAA and I can also use my state laws or whatever the case may be, since that's going to be what governs my hearing. So let's take a look at this clause and break this down. It says this arbitration provision is governed by FAA. The arbitrator will apply applicable substantive laws, statutes of limitations, and privileges. The arbitrator will not apply federal or state rules of civil procedures or evidence and matters relating to evidence or discovery. So they're letting you know right now, the federal rules of civil procedure, the state rules of civil procedure, which is all court processes, does not fly here. So all them motions to dismiss and all them the positive motions that lawyers are so used to filing without asking permission to file is not going to fly in arbitration. Also, another thing they're letting you know here is that evidence. So certain types of evidence is not admissible into court, right? So we've seen on TV where like the police obtain evidence, but they obtain it illegally, so it's not admissible in court. Because the arbitrator is the ultimate and deciding factor on what could fly and what cannot fly in arbitration, things that may not work in court could possibly work in arbitration. So another example of that would be hearsay is not admissible in court. But hearsay might be admissible here in arbitration if the arbitrator decides that after hearing the person's hearsay that, hey, this is actually valuable, I want to consider this hearsay as evidence and make my ruling using this hearsay. So when you see stuff like this in your agreement, it doesn't necessarily mean it's a good thing, but it also doesn't mean it's a bad thing. Because while arbitration is a lot more flexible and lenient than court, it could also mean it also allows for the arbitrator to be the ultimate ruler, essentially. So the arbitrator don't have no boundaries on what they can and cannot do. But so far, arbitration have been most favorable to the consumer. So that'll wrap up this lesson. I'll see you in the next one. Welcome back. Now we're going to look at what it looks like when a company gives you the option to reject the arbitration agreement. So most of the time, whenever I've seen the right to reject the arbitration inside of an arbitration agreement, it has always had these three things. They're going to always tell you where to mail that notice to, that rejection notice to. They're going to give you a set time frame in which you have to do it by, and then they're going to tell you what information they need from you to make sure they put that on file with their company. So let's look at this one. It says you may reject this arbitration provision by sending a written rejection notice. So that is the type of notice you need to send them. You need to send them a rejection notice, and this is how you need to send it. So you're going to address it to American Express, P.O. Box, El Paso, Texas, the zip code, and then they said, or you can go to this website for a sample rejection notice. So if you're not even sure what it's supposed to look like, American Express gave a nice little sample notice here. So if any of you all have American Express credit cards and you didn't reject it, chances are you cannot reject it at this time, and you don't want to reject it because arbitration is very consumer friendly. It's always been beneficial for consumers, and consumers tend to win more in arbitration than they do in court because, like we looked at in the previous slide, the procedural errors that a lot of consumers tend to make as pro se clients, because procedural rules does not normally apply in arbitration, it's much more lenient and allow consumers to really get across the point that they're trying to make. It says your rejection notice must be mailed within 45 days after your first card purchase. So in the American Express agreement, they say after you swipe that card, after that very first purchase, you have 45 days from that point to reject it. Most other agreements that I've seen that had the rejection option in there, it was 45 days from the day you were approved for the card or the day you applied for the card. So this is actually pretty lenient because maybe you might not make a purchase for a week or two after you get your card. And then it says you have to state that you reject the arbitration provision and include your name, address, account number, and personal signature. So you must sign this. So like I said, they're going to always tell you what they need from you within that rejection agreement, what all has to be in there. So in order for the rejection to be valid and accepted for American Express, they're saying your name, address, account number, and a signature. Your signature has to be on there. No one else could sign the rejection notice other than you. So if you fall outside of that 45-day period, let's say that you made your first card purchase, and then 50 days went by, and then you decide you didn't want to do arbitration, it would be too late at that point. because they only have to honor it before the 45-day period. If they come in after the 45-day period, then they don't have to honor it. Another thing that I've seen sometimes in arbitration provisions when they do allow the option to reject or opt out of arbitration is they actually have you sometimes send it proof of certified mail or some type of signature receipt. That way, you have some form of tracking on it essentially. But that will wrap up this lesson. I'll see you in the next one. Welcome back. Now we're going to look at pre-arbitration notice, also sometimes called a claim notice or a notice of dispute. So this type of notice is usually most commonly found in telecommunication agreements and in credit card agreements. So usually those type of companies such as T-Mobile, Sprint, AT&T, American Express, as you see, is one of them. Credit One, sometimes they'll say, before you file a dispute against us or before you take this step against us, let us try to fix it, right? So this is what this verbiage should look like. Before beginning a lawsuit, mediation, or arbitration, you or we agree to send a written notice, a claim notice, to each party against whom a claim is asserted in order to provide an opportunity to resolve the claim informally or through mediation. And then American Express gave a nice little sample here, but then it also says, notice to us must include your name, address, account number, and be sent into, and then they specify the address. There's a couple of things that I want to point out here. One, if there is a requirement, like in this ARB agreement where it says before you file arbitration, before you file a lawsuit, or before you file mediation, or whatever the case it may be, if it says before filing, you have to send this type of notice, always follow the terms of the agreement so you are compliant with the agreement. The last thing you want is for you to go file an arbitration and then they either one, not answer it, and then you be like, the company didn't answer. What, did you follow the terms of the agreement? Because if the company is looking like, okay, this person filed for arbitration against us, do we have a pre-arbitration notice on file, or did we receive our claim notice or notice of dispute, and they look and they don't see it, then they're probably not going to answer. And they don't have to answer because you didn't follow what you were supposed to do to start with. Or two, sometimes the company will answer and be like, hey, you didn't follow the terms of the agreement. Essentially, you breached the contract at this point because the agreement said to send us a notice prior to filing, and you did not do that. So that could possibly now become a counterclaim against you that they can use because you didn't follow instructions. Another thing that I want to point out here is, like American Express, some of these companies give a very specific address that they want their notices to come to. So most of these companies that get arbitration mail or have arbitration agreements have an address that they want you to send it to. Send it only to that address. Do not send mail all over the map. So don't be sending mail to their headquarters. Don't be sending mail to the CFO. Don't be sending mail to the CEO. Don't be sending mail to the billing department. Don't be sending complaints with the CFPB and the BBB. You don't have to do that. Just follow the directions. If it says send it to this address, send it to that address it exactly how they said to address it. So American Express, say write American Express ADR care of CC Corporation. That's what you need to write on that envelope if you send an arbitration claim notice to American Express prior to filing for arbitration. They're very specific. Just follow the directions. Don't deviate from it so that way you are fully in compliance with it at all times. I always say, whenever you send a pre-arb notice or any mail to any company for that matter, always send a certified mail. And prior to you sending a certified mail, I would take my letter, put the certified mail number on the letter, scan it in so that way I have a copy of the letter with the certified mail tracking number on it. And then that way, if they try to challenge you on whether or not you sent it, you can say, look, this is the exact letter I sent you. Here go the certified mail tracking number, and here go proof from USPS that it was delivered to this address that you specified in your agreement. Documentation beats conversation every day of the week. So just make sure you follow the terms of the agreement and you send it exactly how and where they tell you to send it. Other than that, If there is no pre-arbitration notice requirement in there, it's always, like I always say, best practice, send the pre-arb notice anyway to try to allow the company time to settle with you before filing. That way you can save some money on filing fees if you do have to cover it, because most companies would take advantage and go ahead and settle. A couple of companies that do not take advantage of pre-arbitration notice or even answer them is Chase Bank. Chase don't even have a pre-arb requirement the last time I checked. So some of them is going to take advantage. Other companies going to be like, forget it, file, and then we'll handle it once you file. But if it is in your agreement that you have to send it, please send it, follow the terms of the agreement, act in good faith, and follow the directions of the agreement. That will wrap up this lesson. I'll see you in the next one. Welcome back. Now we're going to look at the type of hearing that the arbitration agreement may say you can have or can choose from. So most companies will usually say document only if it's below a certain amount. However, this agreement is very open to letting you choose any type of arbitration hearing you feel is best. I always recommend that people do document only because this way it gives you time to read what the attorney wrote, break it down, research it, understand it, and like really decipher what it is, and then apply appropriate responses to what the attorney wrote. So in this agreement, this is what that verbiage look like. If your claim is $10,000 or less, you may choose whether the arbitration will be conducted solely based on the basis of documents in a telephonic hearing, which I told you guys could also be a Zoom call, or in a in-person hearing, which will be actually like in an actual meeting room. So some companies, like I said, like Mercedes-Benz, I believe if it's over a certain amount, it has to be heard either telephonically or in person, where some agreements just be like if it's under a certain amount, then it has to be documents only or whatever the case may be. If you choose a telephonic or in-person hearing, just make sure that you are super savvy with the law and that not only are you able to respond to what is being said or asked you, but you also understand exactly what is happening, because they're going to use words and jargon that's probably over your head because you're not a trial attorney, you're not used to being in litigation and stuff like that. So you don't have the same grace and time that you have with a documents only, where you get to stop, understanding all that stuff. So because of that process and because of how that hearing takes place and stuff like that, you just want to make sure that you're well read, well spoken, quick to listen, and slow to respond, because if you say anything, it could possibly trap you and hurt you in the long run, especially if you don't answer a question correctly. Even though you may have told the truth, if you answer it incorrectly, essentially, you could have hurt your own case. So when choosing the type of hearing, pick documents only. I've been doing documents only for a very long time. I have never had a problem winning cases with documents only. Most of the time, they're going to settle before it even gets that far. Most of my cases that I have settled after I had to submit my first set of documents or whatever, most of the companies came back and settled right after that first initial document that I had to submit. It's only been a couple of times where I dragged the company through ARB, but that was just me being on some, I felt like it. But most of the time, documents only suffice. Your claims usually don't be over $25,000. If they are over that amount, some agreements will not go ahead and do an in-person or telephonic hearing. But this agreement, as you see, $10,000 or less, it ain't no cap on how much it can go up to, and they'll let you choose whatever type of hearing you want to choose. In this case, if you're super savvy, I would choose an in-person hearing or a telephonic hearing just to run the tab up on the business. But you can always choose documents only, get it over and done with quicker. And then, like I said, you will have the grace that you need and the time that you need to look over everything, break it down, understand it, and then respond appropriately. So that will wrap up this lesson. I'll see you in the next one. Welcome back. Now we're going to look at the type of claims that most arbitration agreements will allow you to bring into arbitration. So most agreements will have verbiage such as any issue or dispute, any and all claims or dispute. That type of verbiage is all inclusive, meaning it means everything. There's nothing that could be outside of anything in all. So essentially, whatever issue you have in, dispute, claim that you have against the company, you can arbitrate. So in this one seems to be worded a little trickier because most of them, like I said, you will see the any and all claims or dispute, any and all claim issues or disputes like that. This one say a claim means an issue or dispute involving these deposit terms or any prior deposit agreement on your account. The claimant is involved. A claim may involve your account application or activity in your account. A claim may also involve advertising benefits or products related to your account. A claim may involve action or inaction. Claim may exist now or arise in the future and may be for money damages, penalties, or injunctive, declaratory, or equitable relief. So essentially, they covered all the different types of claims that you can bring or whatnot. When they say may involve an action or inaction, you can actually file a lawsuit in court against a company for failure to do something. So that's an inaction. So they're telling you still have that same capacity in arbitration. Even if it don't specifically say that in the agreement, a claim may involve an action or inaction, any claim or dispute would include inactions. So by the company not doing something they were supposed to do, that is an inaction, essentially. So now you can file a claim because it will still fall under any and all claims, or in this case, it falls under the claim may include an action or inaction. Most agreements is not going to lay it out very specific like this. They're going to usually say any and all claims, so that will cover you for everything or any and all disputes. But I want to show you guys this one because this one looks a little different than what the standard looks like. But the standard will usually say any and all claims or disputes. In that case, if you see an agreement where it says an exclusion, where it lists out things like this, and it says except these things, then if your claim or dispute falls within the list of exceptions, which is things you cannot bring into arbitration, then you cannot arbitrate those claims. So you will have to sue on those claims. But if it does not fall within the list of exception and it's not a part of that, then you should be able to arbitrate it. Other than that, I believe that this will wrap up this lesson. So I'll see you in the next one. Welcome back. Now we're going to look at fees and payments. So previously we looked at how much does arbitration cost. Now we're going to look at who pays what and how much, essentially. So there's two different payment provisions that I've seen in arbitration agreements. So I've added both of them so that way I can show you guys the difference between the two. So in the first example up here, this agreement said you will be responsible for paying your share of the arbitration fees, and we will be responsible for paying any additional arbitration fees. So essentially, this company say, look, you pay your $225. After that, we got everything else. This is a very favorable and ideal arbitration agreement as far as payment and fees go, because that means even in the event that you lose, you would not owe the debt plus arbitration costs. Because some companies request their money back that they had to pay in order to defend the company in arbitration against you. So under US, this is typically what you will see is you pay your share, they'll cover everything else. Sometimes you will see super nice ones where say we will cover all fees, including your fees up to $5,000. So if you see that, that's even better when they say they'll cover all the fees, including your fees up to $5,000. That's amazing. That's favorable to you. Now, sometimes we see arbitration agreements that says something like this, have this type of verbiage in there where it says the arbitration provision to the contrary, if the arbitrator finds that the claim or defense is frivolous or asserted for an improper purpose as measured by the standards set forth in the Federal Rules of Civil Procedures 11B, then the arbitrator may award attorney fees, attorneys and other fees related to such claim or defenses to the injured party. So essentially what that means is if you are found to have brought a frivolous claim, so a frivolous claim could be anything, essentially that means your claim did not meet its elements and they called it frivolous. Now mind you, most of these attorneys, when they respond to arbitration filings, they're going to always say your claim is frivolous because they simply want to discourage you and not fight it. However, if you know you properly built your case and that you met all the elements of your claim, don't take what the attorneys say at value because they say that they template their responses anyway. However, if you see this provision in your arbitration agreement, what that is saying is if you lose this, we're going to request, or we can request, that you cover our attorney fees plus the cost that we had to come out in order to defend against this action. So attorney fees can get wildly expensive, you guys. I was in a case where the attorney that I was going up against had requested like a little over $17,000 in attorney fees. If I would have lost that case, I would have been on the hook for those attorney fees plus costs, the cost of doing arbitration. So I think the cost was around $3,200 of some sort like that. So total for attorney fees and costs was about a little over $20,000. If I would have lost that case, I would have been responsible for paying whatever amount the arbitrator awarded them plus that $20K. So if they have a frivolous line in their thing, make sure that you know beyond a reasonable doubt and with absolute certainty that your claim is not frivolous and that you met all the elements of your claim. If you are not sure of that, then I would not bring that claim, because if you're found to have brought a frivolous claim, you could possibly be responsible for all these attorney fees and costs, and that is not something you want to be on the hook for, because the same way that if you was to win, they will have 30 days to pay you your money. If they are to win, you will have 30 days to come up with their money. So make sure that if you see that type of verbiage, it's really not favorable to you, but make sure that if you do proceed with filing a case against a company that has that type of verbiage in their arbitration agreements, that you know for a fact you have a case. Because I would hate to see any of y'all get stuck with an attorney bill, because like I said, them attorney fees can get wildly high. I had one for a little over $17,000, and I don't want to see anybody get clapped like that. So just make sure that you build your case properly and that you be on the lookout for this type of verbiage in your agreements. That'll wrap up this lesson. I'll see you in the next one. Welcome back. Now we're going to look at what a declaration for attorney fees and costs look like. So like I was saying in my previous video about fees and stuff, where the attorney was requesting like $17,000 in fees, they actually requested $14,000 in attorney fees and then $3,200 in costs at the time. So it came out to a little over $17,000. Plus they had counterclaims and things like that against me. So my total invoice amount would have came out to a little over $20,000. But I'm going to show you what this looked like. So this was the request for the attorney fees. As y'all can see, it was 2 attorneys and a paralegal on the case that was billing this case and working on this case. So attorney fees and things of that nature came out to $14,352.50. I know that sounds crazy. If I would have lost that case and the arbitrator would have signed it and said, hey, give them the attorney fees, this is how much I would have had to pay in attorney fees, right? So then we're just going to go on down. And this is what the itemized report looked like, because they have to show the arbitrator, did you really run up $14,000 in attorney fees? So as you can see, they itemized the charges. How many minutes, like down to the minutes, did they work on it? So this is their hourly rates right here, and then it breaks down to how much time they spent on it. So they spent a tenth of an hour working on it here, so it came out to $42.50 because the hourly rate is $425 an hour. But they itemized it all the way out for the arbitrator to see or whatnot. So I know y'all, this is crazy looking. And then they also requested, where's the cost? Because they did request cost. Oh, here, go right here. So they did request cost of $3,200 in cost right there, which came out to the $17,552.50. So if I would have lost this arbitration and they would have been awarded attorney fees and costs, I would have been out of $17,552.50 payable in 30 days, plus the counterclaims that they tried to bring. Luckily, they did not win. I won, so therefore I did not have to pay this invoice because that would have been crazy looking. But I just wanted you guys to be able to see what an attorney billable hours look like in the case in which I told y'all in the previous fee thing, where if they do say they can request their attorney fees and costs back, what that could possibly look like essentially. See, they charge for reading emails from the pro se administrator. Like, that's crazy. But just wanted to give you guys an idea of what that looked like so that way y'all know it's real out here. Just make sure, like I said, that you know your claim, you meet the elements of your claim, and you don't file anything that's frivolous. So that will wrap up this lesson, and I'll see you in the next one. Welcome back. Now we're going to look at venue. Where can you file these arbitrations at based on what the agreement says? So most companies will tell you exactly where to file your case and who their preferred case administrator is. A lot of agreements will say AAA. Usually if they give you an option and say AAA or JAMS, it's usually always AAA as the forefront. If they allow you to pick any other one, they'll tell you that you and them have to both agree to having another company hear the art. The problem with that is if you get them to agree, you have to get them to agree in writing from their legal department, and that can be an extreme hassle. So whatever venue they tell you to go with, it's just best to go with whoever they name in their agreement. In this example, this company named AAA only, and also said it will be before a single arbitrator and that the consumer arbitration rules will apply. So they're telling you, do not go to JAMS and file for arbitration against a company that listed out just like this and say, go to AAA, we're doing one arbitrator and consumer arbitration rules will apply. If you go to JAMS, they are not required to answer, respond, or pay fees in JAMS because that is not who they listed in their agreement. So if they say AAA, go to AAA. If they give you the options of AAA or JAMS, how we saw in the American Express agreement earlier when I had looked up the agreement using the CFPB site, American Express said you can go to AAA or JAMS. If that is the case, now you have the option to pick one or the other. But if they don't give you that option, if they say only AAA, if they say only JAMS in the agreement, just go with whoever they say to go with. So that way, if they do not respond to the art, you will have them for breach of contract, and you can just pass that off to any attorney to file in state court or federal court for you and say, hey, the agreement said that if they had a claim of dispute, that they will arbitrate it in JAMS or they will arbitrate it in AAA. My client took it to AAA or they took it to JAMS as they said in their agreement, and then this company did not show up, so now it's a breach of contract on their end. Other than that, I think this will wrap this lesson up, and I'll see you in the next one. Welcome back. Now we're going to look at the number of arbitrators and then some of the requirements that they be having on the arbitrators in order to be an arbitrator for your case. So the first agreement that we're looking at, this agreement is calling for a 3-panel arbitration in which you will pay the fees of one arbitrator and split the cost of the third arbitrator, the umpire arbitrator. Now, remember I was telling y'all in the previous lesson when we went over costs, how usually the consumers are only responsible for that $225 and the business usually handle everything else. This agreement is literally saying, no, you're going to be responsible for paying for an arbitrator. We're going to be responsible for paying for an arbitrator. And then we're going to split the cost of the third arbitrator. Arbitrator fees runs $2,500 a day. So that is going to get wildly expensive. If you see verbiage like this in your agreement, it is best just not to argue them and just go to court at that point, because it will be cheaper than going to arbitration. So if they allow for you to go to court and it doesn't say, and it doesn't remove that ability within the waiver and rights clause of the arbitration agreement, which will be always at the top, if it say that you can go to court or to arbitration, in this case, where it's verbiage like this, where it says the party will each separately select the arbitrator, the two arbitrators will select the third arbitrator called the umpire. Each party will each pay the expense of the arbitrator selected by that party, and the expense of the umpire will be shared equally by the parties, unless otherwise agreed to by the parties. So that you don't want. That is not verbiage that is beneficial to us as consumers, because arbitrator fees are expensive and you do not pay those fees after the case is over. You have to put that arbitrator fee money down as a deposit prior to the arbitrator even hearing your case. So if it's $2,500 a day per arbitrator per day, and you have to pay for an arbitrator and split the cost of the other arbitrator, that's $2,500 divided by 2 plus the $2,500 that you have to pay for your arbitrator. That's how much it will cost you per day per arbitrator each time you have a hearing call against this company. That is super expensive. That is the type of verbiage that we do not want to see in our arbitration agreements when they state the number of arbitrators, right? What we do want to see is the second paragraph. The arbitration will be decided by one or more impartial arbitrators selected under the applicable arbitration rules. Now, this is still saying you can choose one arbitrator or 3 arbitrators. And then usually within that agreement, if the payment thing said that they will still cover the fees, because the first paragraph is not normal to see in arbitration agreements, if they still say they're gonna pay the fees and you just gonna pay your $225, or they'll cover all the fees, including the cost of arbitrator and any additional fees, and then you see this paragraph, which is usually the norm, that you can decide by one or more impartial arbitrators, then that's cool. That's the type of verbiage we like. That's the type of verbiage we look for. They also tell you that the arbitrator has to have at least 10 years of experience or be a formal judge. So when AAA goes to give you a list of arbitrators to decide from, they're going to only pick arbitrators that have 10 years of experience or is a formal judge. Those are the list of arbitrators that you will receive and be able to pick from. They also letting you know that the decision of the arbitrator will be final and binding. So in other words, there is no appeals process here like we talked about earlier, but this is the type of verbiage we want. We want this, we don't want this. This is expensive, this is ideal, this is the norm. So that will wrap up this lesson. I'll see you in the next one. Welcome back. Now we're going to look at how awards and appeals work inside of arbitration and what that look like inside of your agreements. So most of the time, arbitration agreements is going to pretty much say that the arbitration agreement is final and binding, meaning you cannot appeal it. A few of them will say that, you can appeal it under FAA rules, but if you do so, you have to do so within 30 days. Very few things fall within the exceptions, so it usually doesn't allow you to appeal. But let's read how this will look in the arbitration agreement. So it says, at the party's request, the arbitrator will provide a brief written explanation of the award. So when I won my case, the arbitrator, they don't just say, hey, you won, and then give you an amount of money. They actually go through in detail why you won, what you did right, what you did wrong. Did you meet the elements of your claim? Did you not meet the elements of your claim? And they're going to do that for both you and the attorney that you're going up against. If the attorney have counterclaims, they're going to tell them if they won their counterclaims or if they lost their counterclaims. And if they lost all their counterclaims, they're going to say that, like, hey, you're not getting this counterclaim, you're not getting your attorney fees, you're not getting this. Like, there is very detailed out. Usually it's like 2 to 3 pages. I think max was like 3 pages maybe. I haven't looked at it in a while. But it's very detailed as to who won, who lost, and why. So they do give a very thorough explanation with the award. And then they'll tell you what the award is, how long you have to issue the award. So essentially they'll say, okay, this is the award amount. This person needs to pay this person within this amount of time. This person needs to do this action within this amount of time. And then as long as everything is taken care of within that amount of time, you're good. If not, then you can go ahead and enforce that arbitration award in court, like I was telling you guys before. It says the arbitrator award will be final and binding. So that's essentially you cannot appeal it except for the right of appeal provided by FAA. So FAA, the Federal Arbitration Act, have very limited reasons as to why you can appeal an award. So if you meet one of those reasons, then you can appeal it. So most of the time, those reasons are very limited. Most people don't meet them, so it doesn't really provide for an appeal. However, any party will have 30 days to appeal the award by notifying the arbitration organization. So in this case, it would be AAA if AAA heard it. If it was JAMS that heard the thing, then it would be JAMS. Whichever arbitration organization, so the administrator of that case would be the one that you have to notify, and all the parties in writing. So if you do it, you have 30 days to appeal it, and you got to notify both the case administrator, the administrator, which would be AAA, JAMS, or whoever you use, and everybody involved in writing that you are appealing this, and it has to be done within 30 days. The organization will appoint a 3-arbitrator panel. So now they're going to appoint 3 arbitrators to pretty much go back through it and vote based on the written submission and any aspects of the decisions objected to. Judgment upon any award may be entered in any court having jurisdiction. So like I said, if they don't follow the terms of the arbitration award, if the arbitrator say, hey, you got 30 days to pay Jen her money, and they don't pay you my money in 30 days, I can take that award to court, take it to a judge, and the judge is going to enforce it, and there's going to be a judgment against the company. Same thing applies. So in that case, like I had showed you guys in the with the fees, where them fees came out to $17,000, and that didn't even include the counterclaims and all the other stuff. If they would have won, and the arbitrator would say, hey, Jen, look, you lost all your claims. I awarded them this in attorney fees. I awarded them their counterclaims. You have to pay $23,000 in 30 days. I have to pay $23,000 in 30 days. If I don't pay the $23,000 in 30 days, that attorney can now take that arbitrator award, take it to a court. The court is going to give a judgment, and then you have this thing called post-judgment stuff that they can do, which is essentially wage garnishment and all of that stuff for not paying the arbitrator's award. So the same way, if you win, they have to give you your money or take whatever actions they're supposed to take. So if you win and they say, pay this person $1,000, delete the account off their credit report and waive the balance, they need to send you proof of all of that within 30 days, and they need to have complied with it and completed it. If not, you can take it to court and enforce it. If you lose, in the reverse, whatever the arbitrator tell you need to do for them, you need to make sure you do that for them too. Sometimes it can be a split decision where the arbitrator might say, okay, you won on these claims, they won on these claims, so you need to do these actions and they need to do those actions. But that's a reason why the arbitrator is going to give a brief explanation as to the award, so everybody understands why they won, why they lost, or what they need to do after the whole case is settled out, and then how long do they have to do those items, those action items, and then if they have the ability to appeal it, and if they do, what are the requirements for meeting the appeal? So like in this example, they're telling you that the requirements for the appeal is the reasons that's listed under the FAA. If you don't meet those, then you can't appeal it. If you do meet those, then you have to appeal it in 30 days in writing and notify everybody. Other than that, I think that'll wrap up this lesson. So I'll see you in the next one. Welcome back. Now we're going to look at the last element of an arbitration agreement, which is the survivability clause. This is by far my favorite part of the arbitration agreement because it is the most powerful part of the arbitration agreements. So let's look into what that look like on arbitration agreements. So this is the standard survivability clause found in most contracts. Every arbitration provision that I have ever seen in my entire life and in the entire time that I've been doing this all have a survivability clause. This says pretty much, regardless of what happens to this account, even if this included in bankruptcy, even if the account is sold or transferred, even if the contract itself is canceled, the arbitration agreement provision is still in play. This is wildly powerful, people, because you could literally have filed bankruptcy on this account or with that creditor. You could have filed bankruptcy. The debt could have been discharged in bankruptcy, and you can still file arbitration against the company if it's still reported on your credit report. Or if you have any issues for any reason at any point in time you had issues with them, you can still bring them to ARB, even if it's not on your credit report. If you had an issue with them that was not resolved previously before your bankruptcy and now you file bankruptcy, guess what? You still can file ARB against them. So let's read this survivability clause. So essentially what it says, the arbitration provision shall survive the full performance of services under this application, any rescissions or cancellation of this application. Meaning that in some states, they do allow you to rescind under state law. So even if you rescinded the contract, or if the contract was canceled, or if the application was rescinded, or the application was canceled, you can still ARB them. Our sale or transfer of this application, so if it's sold to a debt collector, if it's transferred to a debt collector, you can still ARB them. Or our rights under this application. So if they sold their rights or transferred their rights under the application, you can still arbitrate them. Now, you're probably saying, why the application, not the contract? Because everybody have to apply for something before they actually enter into a contractual agreement, essentially. Because these are usually coming out of credit card agreements or whatever the case may be, or some type of phone agreement or something where you sign up for a service. So there's an application for the service essentially prior to signing up. Then it says, any legal proceedings by us to collect debt owed to us. So even if they sued you to collect money owed to them, you can still file for arbitration. And you or our bankruptcy, even if the company files bankruptcy, you can still file arbitration against them. Even if you file bankruptcy, you can still file arbitration against them. So if this don't tell you everything you need to know about arbitration agreements, because whereas the statute of limitations say, hey, you only got 3 years to bring this claim, or you only got 2 years to bring this claim, the arbitration agreement say you can bring this claim at any point in time in your life that you essentially feel like it. That's what this essentially says. That's why I love the survivability clause. This is why I think arbitration is so powerful and is so beneficial to consumers, because sometimes we look at it and be like, dang, the statute of limitation ended, but I never got justice because this company wronged me X amount of years ago. You can still bring that thing back to arbitration and say, look, this 4 years ago, 5 years ago, 7 years ago, your company did XYZ. I had this issue. We never resolved it, and now I'm bringing it to arbitration. And the company cannot say, oh, statute of limitations, because you can say, oh, survivability. And it's going to rock, because the arbitration provision will always prevail. It will be stronger than that of the contract. If there is contract ambiguity, meaning they say one thing at the top of the contract and something else that is in direct conflict with the arbitration agreement, the arbitration agreement will prevail all the time, every time. And as y'all seen in the governing law section, it says that FAA in the arbitration agreement is always going to take precedence. So regardless of what the state law says, regardless of what federal law says, the arbitration agreement overrides all of that. So that'll wrap up this lesson. I'll see y'all in the next one. Welcome back. Now we're going to look at how to actually file for arbitration. So once you already built out your case, once you have everything lined up, once you already established what your claim is, you met the elements of your claim, you got everything in line, now you need to actually get ready and file for arbitration. So I'm going to go ahead, I'm going to screen share and then show you guys what that whole filing process actually look like. So you're going to head over to Google. Once you get to Google, you're going to go to adr.org. You're going to click on American Arbitration Association. And then right here in the top right-hand corner, it says file or access your case. So you're going to click that. Then you're going to come down. It says fast file a case. Click on fast file a case. And then this page is going to pop up. Once this page pop up, file online, you can either file online or you can file by mail. I say file online. It's quicker and easier. Right here it says, it gives you the instructions. To file a new case, you would need to, and then a list of things you need to do. Complete and upload a filing form, which they linked right here. Upload a copy of the arbitration agreement or mediation agreement. So you have to have a copy of the business arbitration agreement because you have to upload that. Pay the appropriate fees. So if the arbitration agreement say you have to pay the $225 your filing fee, and then they'll pay the rest of the fees, then when you go to checkout right here, you're gonna put in $225. If it say we will cover your fees, then you're gonna put 0. If it says that we will reimburse you your fees, then you're going to pay the $225, and then you got to go to the business directly and ask them to be reimbursed for your fees. So just save that payment invoice and receipt that you get showing that you actually paid it. And then it also says, please note all fields below are mandatory and you must attach at least one document. The reason they say you must attach at least one document is because you got to attach and upload the filing form. The next thing you want to do now is you want to complete the filing form. So once you click on filing form here, it's going to bring you to this page, and then you need to find the filing form. So you're going to click on all forms. Well, right here, you can click on consumer demand for arbitration form, and that's going to bring you to this form. So I already went over how to actually complete this form in an earlier video. So just head back to watch the video called completing the demand for arbitration form. And that's pretty much how you complete this form. So you're a consumer, you're going to check this box. You're going to briefly explain your dispute, any amount that's in dispute, any additional things that you're seeking. Let's say you're seeking equitable relief and you want a debt waiver and for them to delete the trade line off your credit report, you would check other and put debt waiver and delete trade line off credit report. City and state, you're going to put what's local to you. Provide your information. If you have an attorney, your attorney information. The business you're going against information, then the business representative, which would essentially be the attorney or anybody that you spoke with at the business. So once you complete this form, you'll save it and download it because you need to upload this form on the AAA site here. So let's say you completed the form, you will go to attach, and then you'll hit choose file and put filing form right here in the description, and then you'll hit save and upload, right? Then you have to actually go through here and fill out your information. So if I was filing this, I'll put in my name, because remember all these boxes are required, a good phone number for you, email address, and then you're going to always put arbitration because you are filing for arbitration. And then please enter any special notes. So if there are none, enter NA not applicable. If the arbitration agreement say that they will cover your arbitration fees, you want to write that in here. Please see agreement. Business will cover consumer arbitration filing fees. Let them know that in their arbitration agreement, they agreed to cover the filing fees. So then you're gonna also attach the agreement. So you'll hit attach, you'll hit choose file, and then you'll go ahead and find the agreement on your computer. So like the American Express agreement, let's say we was arguing American Express, we'll upload the American Express agreement that we looked at in a previous video. We'll type in right here, agreement, save, and then that will upload in this section. So you should have the arbitration filing form, the consumer demand for arbitration form up here, loaded, and then you should have the actual company's arbitration agreement loaded as well. Now, let's say American Express said they will cover your filing fees. You'll hit $0 right here because that's what the agreement said. You'll make sure you put in the box that the business agreed to cover the consumer arbitration filing fees, and then you will hit submit. I'm not going to hit submit because if I hit submit, it's really going to generate a case number for me, and I don't want that. So, but that is how essentially you will file for arbitration. Another thing that I wanted to share with you guys is that whatever forms or documents that you upload to that part of the arbitration filing, you also have to print that out because the business needs to receive that as well. So I know that's like a lot of different forms. because two of them is required: the arbitration provision from the company plus the filing form. If you had the arbitration notice, if the arbitration agreement said that you have to file a pre-arb notice or submit to them a pre-arbitration notice or a claim notice or notice of dispute prior to filing arbitration, that is something else you would want to upload with your filing stuff. So I'm going to put together a checklist for you guys so that way you make sure that you upload all the forms that you need to upload. If you're not sure on how to fill out any of the forms, the consumer demand for arbitration form, I went over that on how to fill that out in the previous video. So go back and look at that video on how to exactly fill that out and what each box means, because I broke all that down already. But other than that, that's exactly how you file. That's how you will submit it. And then once you actually hit submit and it generates that case number, you want to print all of that stuff up, stick it into an envelope, and mail it to the business or businesses that's associated with that filing. So like I said before, I'll put together a checklist for you guys so that way you don't miss no steps. And that will wrap up this lesson. So I'll see you in the next one. Welcome back. So now we're going to take a look at how to file for arbitration with JAMS. So let's get into it. So we're going to head over to Google. When we get to Google, we're going to Google jams.adr. And then we're going to click on the first link that actually pops up. Then once we get on this page, we're going to go over to submit a case. And then once we click on submit a case, we're going to click on Arbitration North America. And then we're going to click continue. And then this message is going to pop up. To submit a case to JAMS, you first need to sign in or create an account. So then once we see that message, we're just going to hit continue. So once you hit continue, you're going to be brought to the screen. So if you don't have an account, you're going to click right here, create an account. And then you're going to put in your first name, last name, a good email address, because whatever email address you put in right here, this is pretty much the same email address that they're going to send all the communications to regarding your arbitration case that you have with JAMS. Put in a phone number, and then you're going to create a password that meets these standards. And then you're going to check this box right here that says, I agree to the terms and services and the privacy policy, and create an account. Once you actually create your account, you're going to receive an email verification pretty much to verify that you did try to create an account with JAMS, and then you'll be able to log in. Now we're going to switch over to the login screen so that way y'all can see what that look like once you actually log in. So once you log in and you put in your username and password, this is the screen that's going to pop up because we hit to submit a case. So when you get on this screen pretty much is going to give you all the instructions. So a demand for arbitration form. Complete this online form and provide all the required details. So with AAA actually give you a PDF that you got to file, and then you have to upload the PDF back to the system for them in order to complete the arbitration form. With JAMS, the form is automatically built into the portal, so you don't have to worry about uploading the actual demand for arbitration form. Proof of service of the demand on all other parties. Upon completion of the online demand, you will receive an email containing your submission to JAMS, which you may use to serve on the other parties to the arbitration. You may also upload a proof of service after the completion of this online demand form. So like they said right here, once you actually complete this form, you're going to get an email confirmation, and you can use that email confirmation to serve on the other party. So with JAMS, you have to send at least certified mail or registered mail because it has to have some like type of proof of tracking. So I usually do certified mail, and then what I do is I take the certified mail receipt from the post office and upload it inside of my JAMS portal, because as you see, we logged into my portal. That's why my initials is right here. But you'll upload it to the portal because it's going to show the case name and the case number, and then it's a file upload, and then you'll upload it right there in the file upload as proof of service. So entire contract containing an arbitration clause. So to the extent that there are any court orders or stipulations relevant to this arbitration demand, e.g. a court order compelling arbitration, please also include. So let's say for an example that this company has sued you, and then you have filed a motion to compel arbitration, and then the judge had ordered you guys to actually come to arbitration. You will have to upload that court order from the judge that the judge issued showing that
y'all was compelled to actually come to arbitration. Otherwise, if there was no court action, you still have to upload the entire contract with the arbitration clause. So this is one of the steps that I tell you guys before even filing for arbitration, is to collect all your documentation ahead of time, because you're going to need the contract, terms and services, and all that good stuff in order to upload, especially if you're working with GEMS or you're going through GEMS. You need that entire contract plus the ARB form. Administrative fees. So for two-party matters, the non-refundable filing fee is $2,000. For matters involving three parties or more, the non-refundable filing fee is $3,500. The entire filing fee must be paid in full to commence the proceedings. Thereafter, a case management fee of 13% will be assessed against all professional fees, including time spent for the hearing, pre and post hearing, reading, and research and award preparation. GEM also charges a $2,000 non-refundable filing fee for counterclaims. So let's say you have an arbitration agreement, and in the arbitration agreement, they say you can choose GEMS or AAA. If you file an ARB with GEMS and the business agreed to pay the filing fees, the business will have to pay $2,000 filing fee, as we saw right here, because it's a two-party matter, and that's non-refundable. After they pay that $2,000 filing fee, if they want to bring in a counterclaim, they have to pay another $2,000 to bring in a counterclaim. So as we seen with AAA, sometimes what'll happen is we'll file claims against the business, and then they'll file an answer and they'll file a counterclaim. And usually most businesses, when they file counterclaims, the counterclaim is going to be breach of contract. So in GEMS, if they want to do that, they have to pay an additional $2,000 on top of the fact that it's going to be a 13% case management fee against all the professional fees. So when they say all the professional fees, that's the cost of the arbitrator. So sometimes arbitrators have deposits as high as $8,000 to $10,000, and then they have hourly fees ranging anywhere from $500 an hour up to $1,000 an hour. So that's going to be 13% on top of all of the case management fees. So that's what that is. So right here, for matters involving consumers, the consumer is only required to pay $250. So unless your arbitration agreement says that the business is going to advance or cover that filing fee or something of that nature, that's the only time you don't have to pay the $250. And then I'll show you guys what to click on inside of here, so that way you can submit the ARB and they know to bill the company for your $250 filing fee. It says CGM policies on consumer arbitrations pursuant to the pre-dispute clauses. For matters based on a clause or agreement that is required as a condition of employment, employees are required to pay $400. We're not going to really worry about the rest of this, because that's as far as like employment stuff, and we don't file employment ARBs. It says a refund of $1,000 will be issued if the matter is withdrawn within 5 days of filing. After 5 days, the filing fee is not refundable. So let's say, for an example, like when I have filed a case against one of these creditors, I have filed it, they had went ahead on, GEMS had sent out the bill, and the creditor was like, hey, let them know we reached settlement, because we did reach settlement pretty quick. So that way I could withdraw the claim before they even had to pay the $2,000, because they didn't even want to lose no money. So if they wait more than 5 days after paying the $2,000 to settle, then they don't get no money back. If they can settle it within 5 days of paying the $2,000 with you, then you can withdraw the claim, and the company will get $1,000 of the $2,000 back. So GEMS Resolution Center. So right here, you want to select the one that's closest to you, Dallas, Texas. So I will select Dallas, Texas. If you don't see your city and state on the list, then you can you can type it in right here, something that's local to you. I would try to go with the next big city that's local to you. GEMS International. So if you found an international ARB, which we don't do, this is the form you would use. And then GEMS Denver Resolution. So GEMS Denver is a licensee office. This is something that we don't have to worry about either. So a demand is considered submitted for GEMS purposes when the following items have been received. So the demand for arbitration form. So this is what we're about to fill out now. Proof of service. So remember that certified mail receipt, green receipt that you have to upload a picture of. A copy of the entire agreement that contains the arbitration agreement. So your contract plus the ARB agreement. And then if it's a court order, then you need to submit the court order if the judge orders you guys to go to arbitration, and then you have the filing fee. For employment and consumer arbitrations, please note the following. Once the above is received, GEMS will open a file, process the information, and provide invoices to all applicable parties as soon as possible. Y'all, they do bill very quickly, usually within 48 hours of the case being submitted. Until all the above has been received, GEMS may not be able to proceed and may not be able to issue invoices. GEMS receive a large number of filings, therefore GEMS will process the demands as expeditiously as possible. If counsel intends to file 25 or more cases against the same company within a short time frame, please contact the following individuals for the filing process. So if you're on the West Coast, unless you're doing this as a business, then you will be contacting him on the West Coast if you're about to file 25 cases or more. And then on the East Coast is Sarah. This is the case manager. I usually get it for a lot of my cases. And then this is their email addresses and phone numbers. They also pretty helpful, like if you have questions about the process, or if you need any help like submitting something or uploading something, or to say you couldn't get something uploaded, usually they be pretty good. I know Sarah is pretty good about answering emails and giving directions on how to do something. So then we're going to hit next. So now that I'm signed back in, once you hit next, this is the form that's going to pop up. So this is the actual demand for arbitration form. So let's go through this. So the first thing you're going to do is get this drop down, and you want to select JAM Comprehensive Arbitration Rules and Procedures. That's the one that we're going to always use. If you are filing against just another company, then you'll do a two-party matter. If you are filing, and let's say you're filing against the original creditor, let's say for an example, we're going after T-Mobile and a debt collector like LVNV, and it's a three-party matter because it's going to be you, T-Mobile, and LVNV, then you will select three or more parties right here. But for the sake of the example, we'll just do two-party. So then right here it says consumer or employment arbitration. So GMs just need to know what's going on. So for consumer pays no more than $250. The company pays the balance of the filing fee. And then you'll either select this one right here because you will be the person, the consumer, so you won't pay no more than $250. Otherwise, if your agreement say that they're gonna cover everything, then you'll select other right here. So like as you see right here, if you have to pay the $250, you see the payment is gonna be right here because you won't be able to submit this without making this payment. Otherwise, if your agreement say they gonna pay it, you see the payment went away, and then after you confirm details, the case will actually be submitted. So after that, we're gonna hit next. So once you hit next, it takes you to the claimants. So who is the claimant? So the claimant is you. So we're gonna put in our information. We don't have no firm address, and then our city, and then you'll put in your phone number, and then the email address. Oh, they said I gotta okay. So once you put in your information, that's the claimant. So me right here, Jennifer Sanford, I'm the one filing this claim. Now, sometimes people will ask, but what if we got court ordered? Would I still be the claimant? Yes, because you're the one that was ordered by the court to file the arbitration or file the claim. So if that's you and you're bringing the case, you still the claimant. So you're gonna hit next. And then for the respondent information, this is the party to whom the demand for arbitration is made. So let's say for an example, how we were saying we was going after, we'll do LVNV, that's the company name, and then you can just type it in again, LVNV right here, and then we'll just type in the company address, and then we're just gonna make up a city and state for them. Well, this information is where you'll get from them. So you can either grab the company name, the actual company name and address straight from the website, like off of their corporate address or whatnot, and put that in here. Or if you have a good mailing address or something like that that you have already used, or email address for them that they have responded to, then that's the information that you'll add right here. But if you're not sure this information, you can just add it straight from Google, like whatever information they have as far as like their corporate information. And then for the respondent attorney or representative, let's say that you actually know somebody from the company because they been responding. So let's say you sent off your pre-arb and an attorney actually made contact with you during a pre-arb, or somebody responded to a CFPB complaint. If an attorney responded, I would put the attorney first and last name. Whatever law firm they work for, you will see all of this information in a signature block. You don't need their bar number because not all of them put it in there. Then whatever address for the law firm that they work at, you can usually Google the law firm and get this information, but most of the time all this information is going to be available in a signature block. If you don't have this information, that's fine. It's not required for you to have it, but the more information you can add, the better. So we're just gonna hit next. And then the nature of the dispute. So we are not checking this box because we do not want no mediation. We just want to go straight to arbitration. So right here for claims and relief sought by claimant, I like to say attach file. So right here, I'll put something very short and sweet, like LVNV violated 15 USC 1692 CC. Let's say we did a CC case and is liable under 15 USC 1692K. Please attachment. And then my attachment will be my complaint, like my pre-arb letter where I actually detailed out some of the stuff that has happened. Also, if you're gonna bring in any other claims and stuff like that, this will also be the time to do that. So let's say like in my pre-arb letter, I had only put like the CC violation, but I want to bring in misrepresentation as well. I would say LVNV also violated or also misrepresented the balance and violated 15 USC 1681 2B and is liable under 15 USC 1681 police attachment. So everything as far as my claims and stuff that I want to bring, you can go ahead and throw it in here because we actually filing for ARB now. And then just make sure all these claims, if they're not in your pre-ARB letter, then you are going to go ahead and either redo it, like you can attach the pre-ARB letter showing that this is the stuff you already sent and stuff like that, or you can just attach a new complaint essentially. So this complaint will actually serve as the basis of the dispute, and then that'll detail out all the stuff that you actually want to bring as far as claims you want to stack. The amount in controversy, here you can pretty much type in either the amount that is reporting on the credit report or the amount that it is that you are so because you can always change this amount on a preliminary call, so that way they know what amount is actually going for. So let's say I want $5,000 in damages, I could put the $5,000. Let's say it's a $700 medical bill on my credit report, I could put the amount of controversy is the $700 that's on the credit report. But it's some leeway, they don't make this number a fixed number. Like I said, you can always change it when you actually get on the call. So then we're gonna hit next. Now this is the agreement. So remember, you got to have the entire contract plus the arbitration agreement, and it says please cite the location, page number of the arbitration provision. So sometimes agreements could be like 20 some pages, so you will just pretty much say the arbitration provision is on page 17, and then let's say it's paragraphed out, paragraph 27 or something like that, and then you'll just leave it just like that. We don't have to worry about this because this is for employment purposes. And then right here, if you want to expedite your ARB matter, then you can check this. So usually I check this because I always want to try to get through arbitration as quickly as possible because my case is already be built. I have everything I need and I don't need discovery. So I usually check that box. And then right here, you're going to attach the entire contract with the arbitration included. So if they sent you 2 different PDFs, you're going to have to use the PDF merger to merge both of those PDFs together. So that way you can upload one file right here, which will be the contract and the ARB provision. So after that, okay, so now that we log back in, okay, so once you hit next, you're going to go to consumer and employment. So on this page, it's going to ask you if it's a consumer arbitration or an employment arbitration. You're going to hit yes, this is a consumer arbitration. And then since it's not an employment, we're just going to skip this part. And then fee waivers. So waiver of arbitration fees in certain states such as California, New Jersey, Washington, D.C. The law provides consumer as defined above with a gross monthly income of less than 300% of the federal poverty guidelines are entitled to a waiver of the arbitration fees. In those cases, the respondent must pay 100% of those fees. Consumers must submit a declaration under oath stating the consumer monthly income and the number of persons living in his or her household. Please contact GEMS at this number for further information. So when you call that number, they'll actually email you the form to fill out a fee waiver if you fall within these guidelines. So only thing we click in here is yes, this is a consumer arbitration. And then we're going to go ahead and hit next. So once we hit next, at this point we are on the submission information. So you'll just pretty much put in your name and everything again because you're about to get ready and submit everything. I don't know why it's not letting me put it in the email, but it should pop up to where you can put the email in, and then you agree to the terms and services, and then you'll hit next. I hope this is submitted. Okay, and then this is the confirmation page, so you'll pretty much go through here and make sure everything is correct as we typed it in or whatnot, and then hit submit form. So once you hit submit, then your case will officially be submitted. After your case is submitted, it's going to take you back out to a screen like this, right? So once we get to this screen, the filing fee is 0 because we said that the company was going to pay all the filing fees or whatnot. So that'll be 0. They'll give you the location. They'll tell you who your intake manager is and all that good stuff. Once that's done, you see how I attached this proof of service for this case? So since I had attached the proof of service, it'll say attached. So here, once you go to view submissions, when you go into view submissions, then you'll be able to actually upload. It'll give you an upload button to upload files and documentation. Other than that, that's pretty much how you file an arbitration case with GEMS. I hope this video was helpful, and I'll see you guys in the next lesson. Welcome back. Now we're going to take a look at the arbitration checklist. The purpose of the checklist is to help you execute the arbitration process properly from start to finish. So let's get into it. Step 1, you have to obtain the agreement. So, like I told you guys before in previous lessons, if they don't have an arbitration agreement, you cannot arbitrate that company. They must have an arbitration agreement in order for you to arbitrate them. Otherwise, you have to try to get them to agree in writing to agree to go to arbitration. So, we did a video lesson on how to find the arbitration agreement in one of the previous lessons. So you want to pretty much run through that lesson if you're still not sure on how to find it. But to quickly run through it, you can get it from the creditor directly by calling and asking for it. If you have your original copy, that's always the best copy. You can either find it on the CFPB if it's a credit card agreement, or through ADR Lightberry if you're able to find if they have one on file with ADR. Once you get the arbitration agreement, you need to decide. You need to write down where did you get the agreement from, because sometimes what will happen is they will try to challenge you on the validity of the agreement. So if you can say like, hey, I got this agreement from your company, I had called and asked them for a copy of my terms and conditions, and this is what they sent back, and they had the arbitration provision within those terms and conditions, then you know you have the correct agreement for the product that you have with that bank. So once you obtain that arbitration agreement, you want to head into step 2. So that'll wrap up this lesson. I'll see you in the next one. Welcome back. Now we're going to take a look at step 2 of the arbitration checklist. So once you obtain your arbitration agreement, it's time to review it for those elements that we talked about in the previous lesson. So the first thing we want to see is the waiver of rights. Is the arbitration agreement mandatory? Welcome back. Now we're going to take a look at step 5, joining and consolidation. You only have to do step 5 if you file in arbitration against more than one company for the same account. So if you only file an arbitration against one company, let's say, for example, you only filing it against Verizon, you do not need to do step 5 because you're not including anybody else with it. But let's say in this example, you are filing an arb against Credit One because that's who has the arbitration agreement. Welcome back. My name is Jennifer. I will be your course instructor for this module. And in this module, we're going to cover